Yeah, you mentioned that we will have definite numbers in fire redress certifications. Did we get those?
No. January.
January. Okay. And also, I guess I missed this during the October meeting. On page 2 of the minutes, there's a comment on the new online portal for submissions to the law department.
For rules.
It's for rules. So we submitted
Through this portal for the first time.
for the first time. Got it.
We
Okay.
had to create an account.
Okay.
It wasn't so simple as it was before.
Good. Okay. Thanks.
Thank you. Is there a motion to accept the minutes?
So moved.
Thank you, Mr. Singletary. Is there a second?
Second.
Thank you, Mr. Delaney. Ms. Rivera, can you please poll the board members?
Mr. Kudinski?
Yes.
Mr. Barber?
Yes.
Chief Rogers?
Yes.
Mr. Delaney?
Yes.
Mrs. Secretary?
Yes.
Ms. Rajan?
Yes.
Ms. Roseman?
Yes.
Chairperson Patino?
Yes.
8 in favor, 1 absent.
Thank you. Next on the agenda is a report of our executive director, and we're going to go a little bit out of order. We're going to do staff reports, then we'll do the cases, then we'll turn to the presentation from our legal bomb, and then the discussion of rules.
Okay. Good afternoon. It is with great pleasure that I introduce 2 new staff members. First, to my right, I introduce David Montminy, the Loft Board's new Deputy Executive Director and Deputy General Counsel. David comes to the Loft Board after spending 15 years at HPD litigating against owners for violations of the Housing Maintenance Code. He also helped HPD start its then new, anti-harassment unit. Between his time at HPD and the Loft Board, he stayed at home with his 2 young children and settled sibling disputes on a daily basis. Second, I introduce Michael Diometti, back there. The Loft Board's new paralegal. Michael comes to us from the law department where he worked in the child support division. Welcome to the Loft Board, David and Michael. Since the October meeting, we've had 14 legalization and narrative statement conferences and 2 site visits. Next, I want to share some case statistics for calendar year 2025. Despite our severe staffing shortages this year, we will have closed, if all goes well, again, this board meeting, 81 case dockets, and the board removed 8 buildings from its jurisdiction. And lastly, in my last report of 2025, I want to thank the Loft Board staff, Irma, Howard, Rosa, Tracy, Florence, Nicholas, Kim, and last but not least, our Inspector Lewis, who I believe is the true face of the Loft Board. Your dedication to the board's work is inspiring. It is my pleasure and privilege to work alongside you every day. So thank you very much for what you do. And that's my report.
Thank you. Now turn to the case calendar. We have 1 case on the reconsideration appeal calendar. The case is 476-498 Jefferson Street in Brooklyn, docket number R0392, and Mr. Yeager will present the case.
Thank you, Chairperson Patino. The reconsideration application seeks a review of order number 5238, which granted tenant protected occupancy status. Owner requested reconsideration on several grounds, but only presented argument for error of law. First, owner argued that the Loft Board erred when it required that it prove affirmative defense of deregulation by a prior sale of rights. Owner argued that tenant, as the applicant, bears the burden of proving by a preponderance of the evidence that he was entitled to protected occupancy. As explained in the proposed order, it would be illogical to require that tenants present its spruce first. If the unit was deregulated by prior sale, there is no need to consider tenant's evidence. Second, owner argued that the prior tenant knew of her protected status because she received registration application and signed the sales record form, which cited to relevant sections of the multiple dwelling law. The proposed order rejects this argument. In the matter of Cypress Avenue Realty LLC, Loft Board Order number 5053, the Loft Board rejected this argument that the registration application is not proof of knowledge of protected occupancy status. In this case, the signature on the sales record form is similarly unavailing. Owner's witness offered no evidence about when tenant signed the sales record. Third, owner argues that the prior transaction is a contract and absent proof of fraud, the Loft Board lacks authority to review the transaction. The proposed order rejects this argument. Due to public policy concerns regarding rent deregulation, the Loft Board has authority to scrutinize sales filings. Evidence of fraud is not required to trigger the Loft Board's authority to review sales filing. The proposed order finds that order number 5238 was supported by evidence in the record and denies owner reconsideration application. Thank you.
Thank you. Before we vote, I want to note that there's going to be two corrections in the proposed order on page 2. First correction is going to be in the second paragraph of page 2. It should be on October 22, 2012, owner signed and notarized the sales record form, period, while Grisemir's signature is on the form. It is not clear when she signed it. So we'll be switching the name Grisemir to possessive Grisemir's. And then the second correction is in the footnote on page 2. It should read, while 29 RCMY section 106 I4 has been repealed, the language establishing the burden of proof instead of proof. Are there any comments on this case? Is there a motion to accept the case? Thank you. Is there a second?
I'll second.
Thank you. Mr. Ray, can you please pull the board members?
Ms. Prisco-Leski?
Yes.
Mr. Barber?
Yes.
Chief Rogers?
Yes.
Mr. Delaney?
Yes.
Mr. Singletary?
Yes.
Ms. Rajan?
Yes.
Ms. Roseman?
Yes.
Chairperson Patino?
Yes.
8 in favor, 1 absent.
Thank you. We'll now turn to vote on the case on the summary calendar. Case is 473, 475 Kent Avenue in Brooklyn. Docket number is TR1348 and PO0060. Are there any comments on this case? Is there a motion to accept this case?
I'll move.
Thank you. Is there a second?
I can second.
Thank you. Mr. Ray, can you please pull the board members?
Ms. Prisco-Leski?
Yes.
Mr. Bauer?
Yes.
Chief Rogers?
Yes.
Mr. Delaney?
Yes.
Mr. Singletary?
Yes.
Ms. Rajan?
Yes.
Ms. Roseman?
No.
Chairperson Patino?
Yes.
7 in favor, 1 against, 1 absent.
Thank you. We'll now turn to the master calendar. We have one case on the master calendar. Case is 544 West 27th Street in New York. Docket numbers TR1430 and PO0175. And Ms. Oyegwe will present the case.
Thank you once again. Tenant filed Article 7C coverage pursuant to multiple dwelling laws section 2816 and protected occupancy claim. Pursuant to multiple dwelling laws section 2816, for a building to be eligible for Article 7C coverage, the status requires residential occupancy by 3 or more families living independently for a period of 12 consecutive months between January 1st, 2015 and ending December 31st, 2016, except for buildings located north of West 24th Street, south of West 27th Street, west of 10th Avenue and east of 11th Avenue. For buildings within this designated area, residential occupancy by 2 families is required for Article 7C coverage. Here, tenants allege that Unit 4N, 4S, and 5N in the building were residentially occupied. At trial, tenant provided oral and documentary evidence to prove that Unit 4N, 4S, and 5N were residentially occupied during the window period. However, tenant failed to prove by preponderance of the evidence that Unit 5N was residentially occupied during the window period. Also, tenant failed to prove that they occupied Unit 4N and 4S as separate families living independently during the window period. The proposed order denies tenants Article 7C coverage application and protected occupancy claim. Thank you.
Thank you. Are there any comments on this case? Is there a motion to accept this case? Thank you, Mr. Singletary. Is there a second? Thank you, Ms. Roslin. Mr. Rivera, can you please tell the board members?
Ms. Brusculeski?
Yes.
Mr. Barber?
Yes.
Chief Rogers?
Yes.
Mr. Delaney?
No.
Mr. Singletary?
Yes.
Ms. Rajon?
Yes.
Ms. Rosen?
Yes.
Chairperson Messina?
Yes.
7 in favor, 1 against, 1 absent.
Thank you. We'll now turn to the presentation of Howard Edelbaum, the Loft Board's auditor. Mr. Edelbaum will give you a brief overview of the Loft Board's governing applications for rent adjustment based on good compliance costs. We'll also share some ideas and suggestions to simplify and improve the process to apply for these rent adjustments.
Good afternoon. Thank you for giving me the opportunity to speak today. And before I start, I wanted to make sure everyone has a copy of the presentation. And also, there's a few copies of the application that the owners fill out. So you might want to take a look at that also. And just to let you know, I have a damaged vocal cord, so every now and then I lose my voice. So if that happens, it'll be okay. I'll just take a breath and keep going. So once again, thank you. And I wanted to talk to you about the audit process and highlight why it has become increasingly time-consuming, complex, and extremely difficult. And I also want to make certain suggestions of how to improve the fairness, the efficacy, and transparency at every stage. To give you some overview, under the Loft Law, property owners must legalize residential units registered as interim multiple dwellings, or IMDs. With the Loft Board, sometimes tenants are required to share in the costs involved in construction. Rules of the City of New York allows owners to apply for a rent adjustment so they could recover some costs associated with converting their buildings from commercial or manufacturing use to legal residential status. These applications must be submitted within 9 months of receiving the final certificate of occupancy for residential use and must include thorough documentation of all expenses covering individual residential units as well as common areas. They also must provide proof of payment for every charge. So the audit process. The audit process is documentation heavy. Owners must submit extensive records, including detailed cost breakdowns for each unit, common area, and commercial space. These records also include expenses like architectural, legal, and filing fees. Today, I'll focus on the construction costs. So when the process starts, the owner has to fill out a form called the Chart of Necessary and Reasonable Costs. And you'll see a little snippet of a chart in your packets. This chart is comprehensive. It lists every single expense associated with construction for every residential unit, common space, and commercial area. The chart's main purpose is twofold. First, to demonstrate that each expense was necessary for compliance, and second, to verify that every charge is reasonable. For each expense, such as installing a door, a sink, a window, painting, anything, the owner must provide the vendor's name, invoice number, date, quantity, and the amount actually paid. This is where the process gets technical, very technical. The Loft Board still uses a price list from 1977 to set the maximum recoverable cost for every item category. There has never been an update to this list. Instead, the board uses an inflation index to bring those 1977 prices up to present-day values and applies a fixed constant of 1.283, which has itself been in place since 1990. So to give you an example of what that looks like, an owner purchases a 40-gallon electric hot water heater to be installed in a unit. On the chart of necessary and reasonable costs, the owner must list the vendor for whom the hot water heater was purchased, attach the invoice, and show the actual cost of the item, which in this example is $1,600. The 1977 maximum cost for this item is $450.46. This amount is multiplied by the index factor of 3.125, which represents the inflation rate as of the installation date. The result is $1,407.69, and this is called the index maximum. The index maximum is then divided by 1.283 to determine the adjusted index. In this example, the adjusted index is 1,097.19. The owner must record whichever amount is lower, the adjusted index or the actual amount spent. This lower figure becomes the allowable cost. In this case, since the adjusted index of 109,719 is less than the actual cost of $1,600, the allowable cost would be $1,097.19. Once this form's completed and the owner has all the paperwork, they submit it to the Loft Board. However, in reality, initial submissions are often incomplete or inaccurate. For example, in one audit involving 23 units, I received 3 large boxes containing literally thousands of pages. On review, I found the chart of necessary and reasonable cost was calculated incorrectly. The index factor and 1.283 constant weren't applied at all. This triggered a lengthy round of communication between attorneys, owner, and the loft board, and each time the application needed revision, causing further delays. Even after the chart was redone, the index rate used was incorrect, and then there was another revision. On top of that, invoices and payment records were missing. This example underscores how before the loft board can even begin to determine rent adjustments, procedural and documentation issues could already delay an audit. So once all that documents are in, the first step in every audit is to confirm receipt and completeness of all required documents. Once this is done, the loft board must review the chart line by line, often dozens of items for each unit, matching each expense with a valid vendor invoice. Confirm the date when the work was done, verify that each charge applies to the correct unit or area, confirm every expense was truly paid by viewing canceled checks or credit card statements or bank transfers. So the remainder of the process falls into several main stages. Document review. As I mentioned, each expense is checked for completeness, looking for a matching invoice, proof of payment, and all vendor details. Each line item is compared to the 1977 price chart index for inflation and adjusted using the 1.283 constant I mentioned. Then, after you tally all the costs, they must be proportionally divided, residential, common, and commercial spaces. This means calculating the fraction of the building that is for residential use. For example, if residential floor space is 3,295 square feet out of a total of 13,000 square feet, which would be 26%, then 26% of common area costs would be billed to the tenants. So all common area costs are multiplied by 0.26 to calculate how much would be allocated to each tenant. Expenses for commercial areas are only allowed if they directly benefit tenants. So after we get the total of the construction costs, there are additional charges. There's municipal fees, there's architectural and engineering fees, that all has to be documented. And with both legal fees and architectural fees, it's either the total costs or 7% of the allowable construction costs, whichever is lower. Also, there might be an extraordinary legalization cost using the lower of the total incurred, or 7.5% of allowable construction costs. Once all the costs are totaled, including construction and the fees, the per unit total is divided by 120. So increased rent can be spread over 10 years and remain manageable. If the owner includes financing, the term is extended to 180 months or 15 years. So after you've determined how much is allocated to each tenant or each unit, the common and commercial spaces, a letter is prepared to go out to each tenant. Tenant letters must be prepared For each unit, each letter outlines the findings, all supporting documents, and guides tenants through the objection process. In each tenant letter, the Rent Guidelines Board increases are also included and clearly explained. These increases are applied to the base rent that was in effect prior to legalization. Following the Rent Guideline Board percentages, the letters outline how the initial legal regulated rents are calculated and how the rent adjustments based on code compliance costs are calculated. This transparency helps tenants understand the rent owed and ensures that all adjustments are consistent with governing law. The rent adjustment-based code compliance costs do not become part of the regulated rent, but it is additional rent that must be paid. In accordance with Loft Board regulations, tenants are offered under the same terms as rent-stabilized tenants. Each tenant has the right to choose a 1-year or 2-year lease. If no selection is made, the lease automatically defaults to a 1-year term. The tenant letters will also explain the retroactive and proactive rent payments. So to break that down, the retroactive increase is when the rent adjustment begins on the first day of the month following issuance of the residential certificate of occupancy and continues through the end of the month that includes the 10th day after the Loft Board mails its final rent adjustment order to the owner and affected tenants. After that date, the prospective rent, which includes the approved monthly increase, applies. For example, if a certificate of occupancy was issued in January and the Loft Board mailed its final order on October 10th, the retrospective period would run from February 1st through October 31st, with the new prospective rent taking effective November 1. The prospective increase. The prospective rent increase is calculated by dividing the total approved code compliance cost for each unit by 120 months, 10 years, resulting in a monthly surcharge that is added to the legal regulated rent going forward. For example, if the Loft Board approves $60,000 in allowable code compliance costs, the monthly prospective increase would be $500 per month, 60,000 divided by 120. So I know it sounds like totally tedious and crazy making, which it is.
But only for those 10 years?
Say that again. Oh yeah, after that period is supposedly paid out.
And then the rent goes back to just
Right,
like
yes. Audit challenges. The audit, as I mentioned, is labor intensive and plagued by recurring issues. Missing invoices, incorrect application of index factors, omitting the constant, or charging costs to the wrong unit. Every mistake or missing document triggers a one-time consuming communication loop between myself, the attorney, the owner, and the Loft Board overall. This back and forth can draw out an audit for months, complicating matters. Many owners pay expenses from several different bank accounts. Sometimes owners use 8 or 9 or sometimes 10 bank accounts to pay for the various expenses. And it makes expense tracking both strenuous and error-prone. Not only do missing or inaccurate records delay the process, but the persistent use of outdated methodology and a 48-year-old cost chart only makes matters worse. For example, items like HVAC installations, roof replacements, or accessibility lifts, or dozens of others weren't on the list in 1977. So that makes it extremely difficult, because then we got to research those items, and myself, who's not an architect, got to figure out how is this reasonable or how is it necessary. I have no idea. So then I confer with Martha, I call the attorneys, and we go back and forth, and that one issue could delay the process for months, because you want a price that's fair, but yet, if it's fair and reasonable, you want to allow it. The process is clearly overdue for modernization. Current reliance on an old cost chart and a long-standing constant creates inefficiency and inconsistency and adds unnecessary time and cost. So here are several specific reforms to modernize and streamline this system. Eliminate the chart of necessary and reasonable costs. Instead, require the owner's architect to provide a written justification explaining why any high-end items, perhaps those costing $5,000 or more, are necessary. The reasonableness of each cost would then be determined using certified cost benchmarking software. This approach would help prevent inflated or unsupported charges from being approved. Simplify auditing by excluding minor expenses under a set threshold. The administrative time and legal fees saved would far outweigh the minor costs involved, making the process more efficient overall. Mandate a dedicated bank account for all legalization funds with monthly statements and all invoices submitted to the Loft Board. This reform would dramatically increase transparency and speed up verification. Move to online document submission and end the requirement to deliver boxes of paper materials. This mirrors the best practices of modern audit firms, which use secure digital portals to track documentation, automate calculation, and catch errors early. This would minimize paper use, reduce email delays, and back and forth correspondence, and result in faster, clearer audits. The above suggestions would save a vast amount of money on legal fees. This would allow the Loft Board to charge a fee to owners and apply this money to an online portal system and implement the software that would supply reasonable cost for construction in real time and not depend on a price list from a very long time ago. It would allow for the elimination of the old price list, the inflation index, and the constant. This in turn would cut down on paperwork drastically and decrease the time it takes to do an audit. Adopting these reforms would bring the Loft Board's audit process into alignment with current standards in accounting and compliance, making it more efficient, consistent, and technologically up to date. Lastly, in closing, it's important to remember the goal of any audit, not to punish either side, but to achieve fairness. Tenants deserve transparency and confidence that any increases are justified. Owners deserve clarity and a prompt path to recover legitimate costs. The loft law was designed to balance both interests, to promote safe legal housing and fair expense recovery. Unfortunately, today's audit system is still anchored to outdated prices, formulas, and procedures that don't reflect the realities of modern construction. The true cost of this inefficiency is not just in wasted time and increased legal fees, but also in delayed improvements to vital buildings and growing frustration for everyone involved. By embracing digital tools, streamlining approval procedures, and enhancing oversight, this system can be transformed into one that is truly accurate, efficient, and equitable. Modernizing the process will strengthen transparency and trust in the Loft Board's work. Ultimately, the Loft Law's purpose is to guarantee safe legal homes for tenants while ensuring that owners can recover legitimate and well-documented costs. By updating the system, we can make the process fair, accurate, and efficient, not only for owners and tenants, but also for the Loft Board and the community at large. Thank you.
Thank you.
Thank you.
Thank you.
I have a couple of questions.
Sure.
I wonder why the city just, rather than taking these 1977 figures and then updating them with certain tools, why can't the city make a specific decision of what it would cost for a hot water heater, refrigerator if necessary, and a stove if necessary? I also wonder whether the use of stoves will have to be electric from here on in. Is that correct?
Not necessarily.
And also the price of doors, the price, it just gets befuddling, the price of how much it takes to put a wall up. Rather than taking some figures back in '77 and using a proportion to bring it up, why can't we just decide what would be a fair price for these items?
I agree with you. I mean, that's what the 1977 list was supposedly, but the other thing, not just besides a list of what the prices are, is whether it's fair and reasonable, and also when somebody purchases something, it's never going to match, exactly what the city says it should be, and also an updated list, but how do you, because it's literally thousands of items. And then also, with what those items are, you got to include labor and everything else. So that's why it was suggested that we use a software for that. But an updated list, absolutely, that would be great.
Yeah, it's kind of amazing that this list, which is extensive and inclusive, isn't already computerized where you could just look at X and owner, right? And that I know it's work for the city, but every year the numbers are reviewed and updated. I have a point of clarification question. So and then I know Elliot has more questions. You said that, right, so am I correct that some of the updates, like say a sprinkler system would be a building-wide improvement, and then more specific unit improvements, like the kitchen, are dedicated or so the rent increase for the tenant that gets a new kitchen is just the kitchen kitchen cost, or plus the prorated piece of the sprinkler cost? Or
It's the
the whole building is the whole building?
Well, it's per unit. So the owner would break down the cost for each unit. Like say they buy a bunch of sprinklers for the whole building, it would say, okay, 10 of these sprinklers went into this unit. You know what I
That
mean?
tenant's
Yeah.
rent increases.
Right.
So now, is there a way to take a chart somewhat similar to this and tie it to the narrative statement process? Because that, at the beginning, like, so there's a point, right, where there's an agreed upon scope of work for each department, and for the public spaces, and for the building envelope, and whatever happens. So at that point, everyone has an understanding, generally, things change, but generally, like, what is going to happen in this unit. So you can kind of set up an infrastructure for each of those components of the building at that time, and then as the expenses are made, the owner can plug the numbers in.
That'd be a great idea. That would be great. And if it was automated, maybe once those items from the narrative made it to this portion, maybe the prices somehow could be updated automatically,
Takes a
or,
long
you
time.
know, I mean, it's possible technologically. I
Right.
couldn't do that, but that would be great, and then it updates the list automatically. That would be ideal. And if we did that, then the whole process of how we do it would be completely transformed. And the audits, instead of taking a year, could be done in a month.
Well, they're sort of done in real time as construction
Yeah.
happens. Who's making the decision about whether this update's gonna happen, and then how does it get implemented?
What update, I'm sorry? The update to the rules?
No, the process that we're discussing.
The board's rules.
Got it.
We have to update the rules, the rule making.
Got it.
These reforms have to go through rulemaking?
Yes.
Okay,
This
understood.
is all in our rules.
And the application also.
But the application, yeah, the application has to be updated. But before we can do that, we have to understand what the board, how the board wants to proceed. There were several suggestions that were put out there about the costs, the types of costs. So we would have to, we would have to have further discussions about what costs to include and how to calculate the cost. It's never been dollar for dollar, obviously. That's why we have the indexes. What would the board want us to do? So there has to be some agreement, some guidance from the board about what it is that they want. What is it that you want the rules to be? So this is just an introduction to the process. And we will continue this conversation so that we can understand what it is that the board wants. The next, January, I'll give you the rules so that you see them. I should have, I didn't think of it, but I should have provided them today. So in January, I'll send them over to you so you can understand where in the rules they are, the formulas are. Go ahead.
So does this software, do you have an idea, does a software exist that
Yes.
kind of does this, what you're thinking of?
There's probably at least a dozen different ones, and they all have different specialties. Depends on how many users. Some, there are some free ones, but they're probably not as robust. Yes, so there is software that does it in real time. Oh, and just one other thing that you mentioned, if you do it, match it with the narrative, and it's put on there in real time, then what could actually happen is, one of the reasons I suggest having a separate bank account, because as they pay expenses, they would submit those invoices that following week. And at the end, they would submit a bank statement. And so at the end of every month,
Match it.
right, and that's how every audit works.
Right.
But now, sometimes we get invoices from 10 years ago, and they send us the wrong one, which makes sense. But if you did it in real time, at the end of the construction project, the audit's just about done.
Thank you, this is very helpful.
Thank you. And I know you had,
Well, my basic position about the law board here, and I've been probably a proponent of artist housing longer than anybody else, with maybe the exception of Chuck across the way there. But I think that things have to be fair for the owners as well. Because what we see over and over again, when an owner decides they don't want to convert the place, sometimes we get 500 pages from their lawyers, it's sort of, we generally almost always say it's invalid, right? And God knows how much that much costs. So I'm just hoping that we can make this thing sort of fair, so that potential landlords are not going to get into this thing and observe and not observe what we're trying to do here. And everybody agrees that we need housing in New York City.
Just to say, I agree with you, and I think the owners would be really happy with this change, simply because they would be getting rent increases sooner, right?
Yes.
And rather than waiting 2 years. So, and the tenants would benefit because they know they're getting a price that's justified and it's reasonable. So,
sounds great.
thank you.
Yeah, thank you.
Thank you.
Thank you. Thanks.
Now turn to discussion on several proposed rules, which include proposed amendments to Title 29 of the Rules of the City of New York, Sections 201.1, Section 208S, and Section 211.1, and Section 212. Ms. Cruz, we'll start the discussion about proposed changes.
Yes.
I'll have a copy of the proposed rules.
Yes, I sent them in the link, and I think Ms. Rivera gave you copies today. But also, in the materials in front of you is this chart. I sort of broke down the different changes in the rules, so we're going to go through this. So we're going to start with 212, which is what we've been calling the 7B rule, the Article 7B. So if you go to page 5, that's where the language starts. So you'll see that Article 7B compliance, you can show that the building complies by 4 methods right now, which is the temporary C of O, final C of O. You could submit, I've never seen this, DOB records demonstrating that the alterations necessary for issuance of a residential C of O have been completed. Filing with the Loft Board a sworn statement by a registered architect that the IND has achieved Article 7B. The proposal is just to leave 1 and 2 in place and remove 3 and 4. That's the first change. The second change will be, that we're proposing, is the inclusion of a date in Section 2 that talks about when the rules were, when those rules were effective. So the filing of an alteration application within December 11, 2015. The law department wanted us to put the date there. The next change is the penalty. So actually not the penalty, but the deadline for buildings that submitted this Article 7B certificate without getting a TCO or final CFO. You're still in the Loft Board's jurisdiction. If you remember, we, in going through the buildings list, we identified 33 buildings that had submitted this Article 7B compliance and were still here and had not achieved a temporary or final CFO. We're giving those 33 building owners, or any owner that filed a certificate of 7B compliance. The proposal here is 12 months to get your final or TCO. And if not, then you could be subject to enforcement, subject to fines. The next change, which is section 4, talks about the fines that we're proposing, and it's sort of in the middle. We've added where it says failure to take reasonable and necessary action, failure to obtain a temporary or final certificate of occupancy, and these were the fines. The other changes were sort of fixing citations to this rule. We also added here the failure to file a narrative. We added that to the reasonable and necessary rule, that we can issue the law court staff can issue a violation against an owner if they file what is called now an RCO or an alteration type 1 if you're in biz world. But you don't file the narrative statement with the law court to begin the narrative statement process. So they've met the first legalization milestone, but they haven't followed up with the narrative to begin those conversations with the law board and the tenants about the proposed changes. So if you fail to file the narrative, you can never get a permit, right? Because you won't get law court certification if you don't have a narrative statement. So we added that, we added a proposed fine for failure to file the narrative. And that's it for this rule. Any comments, suggestions, concerns?
I have a question.
Mm-hmm.
At this point in time, since we just got these are not yet public documents.
These are not yet public documents, no.
When will they become documents that can be shared with the public?
I think when the discussion has ended. If you're saying today that this is a perfect document and we're ready for publication and ready for a hearing, then I think it will become public. We do have preliminary certification from the law department. I like to do that first because it's important to get their way in. There's no point in having a discussion here if we don't get way in from the law department. So we have preliminary approval from the law department to have a public hearing on these rules. But if there are any significant changes, then I may have to bring it back for an additional or subsequent approval. But I wanted to bring it to you today so that you can have a discussion about these proposed changes.
Martha, could I give a short update with the Soho No Coalition?
Can we wait till the end? Can we wait till the end?
Oh, I thought we were at the end, sorry.
No, not yet.
You win.
Sorry.
Not yet, not yet.
Lily has no comments on the rules.
I mean, you were quiet for a minute. Okay.
I think this is clear. I think it's warranted. If I understand correctly, we're doing two things here. One is we're closing this door, so we'll only have the 32 to deal with. So people can't do this in the future.
Right.
And then we're setting rules for how that universe of 32 buildings, some of them have been sitting in this particular little Stillwater pond for quite some time, have to proceed. Is that accurate?
Yes.
Yeah. So my only suggestion is, I think, thinking through this, 12 months is too long. I think it should be 6 months. And the reason I say that is because once these rules are public, I think it would be very kind of you to send them to the 32 buildings that are in the Stillwater.
Mm-hmm.
They're public. We're not meeting in December. We're going to have a hearing at the earliest in January. Then it'll take a couple of months for us to pass the rule after we absorb any comment. Then it'll be a while before it goes into effect. So the rule might go into effect in April, May, June of 2026. So we're now going to give them till April, May, June of 2027, after they've had this period of repose for, in some cases, a decade or more. That just, to me, seems overly generous.
if I may, on that point, that might be reasonable if the loft board gave some kind of notice to those 32 or 33 owners that they have to move ahead. But I think a year is not too much to get from a point of total absence and total nobody at the helm to get moving. Maybe there could be something in between where an owner explains what steps they're taking towards filing a narrative statement, or explains what obstacles they might have met, or something of that sort.
But these guys are all past that.
Yeah.
They've gotten the permit, they've done the narrative statement, they've gotten the permit. Somebody says they have the building that's the equivalent of being, either having a TCO or being 7B compliant.
Well, that somebody is dead wrong. That must be so. And things have changed since that time. The
I don't
person
follow.
made that statement. That statement may no longer be accurate.
So why are they still why haven't we been able to affect change if it's not accurate? It's not possible.
Yeah.
My only concern about shortening the time period is, what if it's not the same owner? What if tenants sometimes make changes to their spaces that could affect, like block sprinklers? There may be, given that some of them have been sort of lingering for a very long time, I'm concerned about not giving a potentially a new owner, the opportunity to, to correct this situation, and then be pretty subject to fines. I mean, certainly we will issue a violation, they'll have an opportunity to respond, and we'll have an opportunity to review what it is that they're saying to us. But, so I'm concerned about that. I'm concerned about not giving enough time and then having, people come back and say to us, I need more time, I need more time.
Could there be a series of steps?
Let them apply for an extension then.
Yeah.
Oh, that would require more rulemaking.
But in essence, if we take these 32 owners, some of whom may be new owners, I understand that.
Mm-hmm.
And the tenants may have done stupid things in the unit or in the hallway. I know that's certainly possible.
Mm-hmm.
But if we notify them now that we're moving in this direction, in essence, if we give them 12 months in the rule, that's really way into 2027. It seems excessive to me.
I have a different question. I'm a little fuzzy. Why is there a recommendation? What's the benefit to remove the cure period?
What's the benefit to what?
Of removing the cure period?
For the quarterly reports, because they don't file until we issue a violation. And then they file, and they file all the missing reports, and we can do nothing. So we have a group of buildings that seem to be doing that. So at this point, I want to say that you have to file every 3 months, and they don't file. I had one owner tell me, I'm not going to pay my architect to do this until you tell me that I must do it. I'm like, I don't have to tell you, you're supposed to do it. He's like, well, when I get the violation, that's when I'll file.
So is this meant to be a means of removing an obstacle with regard to enforcement?
Yes. Yes, but we use these reports for a lot of different things, right? Especially in buildings that are asking us for letters of no objection to do work in commercial spaces, right? That's our first stop. We go there to find out where, what are they doing in legalization, like what's happening here. And do we see progress? We go back 6 months, we take a look at what, what was the percentage in 6 months ago? What's the percentage 4 months ago? What is the owner, saying that is the obstacle today? And when we don't have that, it really does, we have to engage with the ownership in a way that makes it a very tense exchange, because by this point, they have a commercial tenant, they're ready to move in, they're ready, they have a lease already in place, and you're not letting me fund my legalization. I hear that all the time. My favorite. I need the money for legalization. I'm like, oh yeah, but I wish I knew that you were doing the legalization. I don't know that you're doing the legalization. I literally had this conversation with someone yesterday.
That's all.
Remember that, Flo? So it's a problem when it's not done.
So I guess going back to the 6 months, I'd like to make a motion that we change the 12 months to 6 months.
You think we can do it? I would be happy.
Well, you could start by seconding the motion. Yeah, I feel that giving this little group, many of whom have sat around doing nothing for so long, what in reality will end up being 18 months from now, roughly, is just, it doesn't make sense.
I'm fine with it too. We'll do the hearing and see who comes forward and what they say during the hearing.
But I would like us to vote to amend what we put out there to 6 months. And if people can give us good reasons why it should be longer.
Yeah, we'll have a public hearing and see what comments we receive. And maybe we can do outreach to the specific group about the hearing as well.
But my only question to that is, I do think there's some merit to the reality that ownership can change. And so if you're changing ownership, how does the 6 months seem mutually beneficial? Is the best.
The assumption is ownership is already changed.
I'm not going on assumption. I'm just saying, if there is actually a change in ownership, an assumption, to now put the onus on the new owner to get it done in 6 months, what is the benefit?
What was that?
Buyer beware.
Buyer beware. But also that would give the new owner grounds to seek an extension based on being a new owner.
Yes. But if I was a new owner, I just bought the building 2 years ago, let's say, I've hired an architect, I got my extension, but I can only extend it for a year. It's now 2 years in my ownership, and now I have to get my CBO in 6 months, even though, 15 years ago, the owner then said this was, or the architect said that this was 7B compliant, but this is, different, completely new and different unit now, because, there have been 5 turnovers, and the tenant has built this out. Circumstances change, I hear that all the time. Even after the narrative, people have heard me say that, this is, why are you filing this post-approval amendment? I'm not sure what it's called, if you'll be involved. Why are you filing it now? He's like, I'm very close to the end, but I had, as-built conditions, because, when I walked into the unit, it wasn't what I saw 2 or 3 years ago. So, I missed this, or this situation, the tenant wanted me to do something else, so now I have to file this post-approval amendment so that I can get my inspections and get the final CBO. Circumstances change, no matter whose fault it is. So I'm concerned about not giving the time, and there are pretty hefty fines here. It's not that, we're saying $1,000. So if we're giving them less time, perhaps we should revisit the fine amounts. But, I'm sorry?
I still don't have any appetite to reduce the fine.
Okay.
But one other question, when you say someone should file for an extension, what's the period for the extension?
Well, you're supposed to file it before the
What's
full
out there?
compliance date, right? But if you're a new owner, you can file it within 3 months of acquiring title,
Right,
right?
and then the extension goes for how long?
Oh, a year.
So if we go 6 months and then they file an extension, it's approved, they get 12 months?
But,
No, I'm saying after the 6.
12 more.
That's what I'm saying, you get 12 months, so
Yeah.
that turns into 18 months?
but that's if you came in, you're a new owner, and it's been less than 3 months,
Right, well,
and,
what I'm saying is respectfully, I don't want to cut you off, respectfully. They check all the boxes, everything that you're gonna say, they check.
Mhm.
So now we're potentially, now that I'm feeling Elliot, second motion, we're talking about from 6 months, from 12 months to 6 months. You file an extension, then you get another 12 months?
yes.
What's the delay?
That's what I'm saying, I'm like, what's the benefit, 18 or 12? All right, I'm ready, let's do it. I got it.
Plus the time between now and when the rule is into
You
effect.
grow a good beard by that time.
Plus the time between now and when the rule goes into effect, which would be a couple of months.
I got it, I'm clear.
Well, why don't we vote? Okay, do it together? Okay, just in case, all right. So the other rule that
Wait a
we're,
second.
I'm sorry?
There's a motion on the table.
We're gonna vote on amending and moving forward, on both rules together. So
Oh,
we can discuss
okay,
the second.
okay, fine.
So the other rule is a protected occupancy rule. And what we're doing here is sort of clarifying the Loft Board's precedent, Loft Board's review of these types of cases where the Loft Board will review all relevant evidence, and explicitly saying here in section 4, subsection 4, that no single one document is not, it will determine the outcome, including a tax return. We're making it very explicit in this rule that that is the Loft Board's position. Any questions or concerns?
I only have one question, and it's not on that language, which I think is clear, but in little triple I, C, oops, sorry. The Loft Board shall consider all relevant evidence presented, including but not limited to. C says whether the individual listed the IMD unit as a residential address on official documents filed with government agencies. Such documents may include but are not limited to a tax return. And we're adding employment records, school records, and bank records. But I don't file my bank records
Agencies.
with the government.
Oh, that's a good one. Okay.
But if you're commercial, don't you have to? Like the developers don't have to.
No, it's like whether you as, so you're filing protected occupancy.
No, I don't
This
think
is
we made
saying,
a connection.
when you use a document that you file with a government agency.
We were just trying to be as inclusive as
And then
possible.
she's listing employment records as an example.
Maybe what we should do is, don't say such.
You know, this is if you're a residential tenant. If you're
Maybe say
applying
the Loft Board
occupancy.
may consider,
You could make another,
the following documents. Yeah, make another little thing.
because it's sort of 2 points, or in my mind it's 2 points, right? Like, so if you're using that, any government document, and then any financial document?
Any other type of document, which employment records, bank records,
Yeah.
you know, cell phone records, cable.
Are you leaving them both in C though, or are you
No.
making a new
We should create a new
category?
Yeah, new category.
Okay.
Maybe if you cross out the word "file with government agencies," then it would say where the individual listed the IMD unit as a residential address on official documents. Such documents may include, but are not limited to, etc. Those are all official documents.
Yeah. that-
Yeah.
Yeah.
Okay.
Yeah. Now we have a couple of minutes.
Wait, I have another typo
Okay.
somewhere, although I made a note to myself and now I can't find it, so I do apologize. My note is on page 4 in paragraph 1, it should be then, not, it should be that, not then. But I'm not finding.
You're saying it should be,
It might have been in the other one.
In the first row?
It should be which, now what?
Oh, I think you already changed it. Did you change that already?
no.
Hold on. Hold on.
No, I didn't.
And should certificate of occupancy be, capitalized?
I tried to take out all the capital. I tried to take them all out. It doesn't need to be capitalized.
It's a proper, it's a thing, no?
I'm gonna check in the definition section, in section 1. If it's there, then we'll keep it capital.
Would it be in the definitions of the MDL? I looked there, and it's.
No, I mean in chapter 1.
In our.
We created a whole,
Right.
back in 2022,
Right,
a whole
in our
definition
definitions.
section.
Right.
I'll check to see if it's there listed as a term, then I will leave it capital.
Heather, what was the word you thought was the wrong word?
It should be that, not than.
The 7 people?
Like I said, I can't find it now. I'm sorry,
Okay, I'll take a look.
but I did find a typo.
All right, I will take a look.
And if you find it, we can just
Yeah,
fix the typo.
yes, exactly. Mhm.
Any other comments on the rules? Seeing none, can we get a motion to move forward with scheduling the 2 rules before us for a public hearing with the amendments we discussed today? Which is, the first amendment is amending section 201.1B6 to shorten the time period to obtain a final residential certificate of occupancy to 6 months from the 12 months in the proposed rule before you. And the second amendment would be to section 208S. That amendment is to remove the terms filed with government agencies in section 208.
Mr. Chairman, can you separate those two votes? Because I can vote yes on one and no.
Okay, so then we'll do it separately, so, which I was trying to avoid 2 votes, but we'll do it separately, so, then we'll start with, a motion to move forward with the proposed amendments to sections 201.1, 211.1, and 212, with the amendment as discussed to 201.1B6, which is to shorten the time period from 12 months to 6 months. Is there a motion to move forward with that proposed rule?
Yes, yeah.
Thank you, Mr. Delaney. Is there a second? Thank you, Mr. Barretts. Mr.
Just a note before, it's in the text twice, and it's also in the fine schedule.
Okay, so we'll make sure it's amended throughout.
Ms. Kuniski?
No.
Mr. Bauer?
Yes.
Chief Rogers?
No.
Mr. Delaney?
Yes.
Mr. Secretary?
No.
Ms. Roseman?
Yes.
Chairperson Patino?
Yes.
Four in favor, 3 against, 2 absent.
Thank you.
Mm.
Can I get a motion to move forward with the proposed amendments to section 208S as amended? We're removing the terms filed with government agencies in 208, subparagraph 3, item C. So it'll read, whether the individual listed in the IMD unit, listed the IMD unit as a residential address on official documents, period. Such documents may include but are not limited to a tax return, employment records, school records, bank records, a motor vehicle registration, a driver's license, or a voter registration.
So moved.
Thank you. Ms. Rosenwicki, can I get a second?
Second.
Thank you, Mr. Singletary. Mr. Rivera, can you please poll the board members?
Ms. Kuniski?
Yes.
Mr. Bauer?
No.
Chief Rogers?
Yes.
Mr. Delaney?
Yes.
Mr. Secretary?
Yes.
Ms. Roseman?
Yes.
Chairperson Patino?
Yes.
6 in favor, 1 against, 2 absent.
So Mr. Barrow is going
Thank you. There's always been a sort of schism between the law board and what is called the joint legal collective quarters for artists. Over 6 years ago, Councilwoman Chin, I'm not sure of Chin, recommended that somebody living in these joint quarters would sell it. They would have to spend $100 per square foot for the potential owner if they weren't interested. And it didn't matter whether the thing is worth $2 million or $10 million, but anyway. And so the NOHO coalition has been fighting this thing for 6 years. Mayor Adams has supported the coalition, and it went before the Court of Appeals, which is the highest court of the state of New York, yesterday. There is no resolution on it, but something kept on coming up, and I finally looked it up, called Nolan. Anybody know what that case is? Well, apparently it gives the city the right to levy certain fares, fees. And of course, the decision will be made by the judge. I have no idea how it was going. My guess is I think because of this Nolan thing, that the coalition's going to lose, but I'm not sure.
Thank you. Any other comments before we conclude? Again, this will conclude our November 20, 2025 public meeting. Our next public meeting will be on January 16, 2026, and happy holidays, everyone.